be seated. Come to order. Court is now in session.
Good morning. Hey, good morning. All right, good morning, everybody. States here. Defendants Rashad Murphy, Davion Murphy, Sean Gathright, and Isaiah Chance are all here. Good morning. Defense counsel's present. Are we ready to proceed?
Judge, can I address the court just briefly on what's happening today, just so I can clarify it in
Sure.
my mind? As I understand it, Judge, we are going to be arguing the motions to suppress.
Correct.
That were, testimony was taken last week.
Correct.
We're going to do all the capital and phase 2 motions.
Yes.
And then the balance of the motions in limine and those related to the gang history, they're going to be done in conjunction with each other on Friday.
That's my tentative plan.
Okay.
Does that work?
Yes, Judge, that would be my preference.
Okay. And, all right, very good. So, on the motions to suppress, do you all have a preferred lineup, or you just want me to pick? Anybody? Okay. All right, Mr. Gonzalez, you're closest to the podium. So, all right, let me just take a look here.
Motion to suppress statements, Your Honor?
Sure, we've got the motion to suppress the cell phone and the motion to suppress statements. So why don't we kick off with the motion to suppress statements? And I'm going to give each side 30 minutes total. So, okay?
Judge, as it relates to Defendant Rashad Murphy's motion to suppress statements, we are seeking to suppress statements made incident to an unlawful interrogation that took place on July 30th, 2024. If the court might remember, this began with the silver Chevy Cruze having been found in Gwinnett County. Mr. Murphy was driving the Chevy Cruze. After he fled from the Chevy Cruze, he was tased and taken into custody. And again, this was in Gwinnett County. At that particular time, as the court will remember, the Chevy Cruze was the evidentiary basis at that particular time. There had been no additional evidence that had been determined relating to Rashad Murphy. And after his being detained in that particular case and arrested for a misdemeanor in Gwinnett County, Detective Ramos and Detective Campbell traveled from Tampa to attempt to take a post-Miranda statement from Mr. Murphy. He was given Miranda advisements as testified to by Detective Ramos, and essentially he testified that there was no evidence at that particular time. They were in possession of no evidence at that particular time linking Mr. Murphy to the homicide. This was simply an alert on the car based on surveillance footage that had been obtained, as well as license plate reader information. During the course of that initial statement on June 26 of 2024, Mr. Murphy clearly and on multiple occasions invoked and requested to have a lawyer, went so far as to say, hey, look, when I get a lawyer later on, I'll reach out to you guys. But at that particular time, Detective Ramos ceased his questioning, and he and Detective Campbell left Jacksonville. It's important to note that during the course of the gathering of this evidence, Detective Drabick had assumed the role in Jacksonville of keeping in contact with Detective Ramos on a regular, I think they almost called it a live basis, updating each other on what was going on and what was happening as evidence was being developed. Detective Drabick also was made aware that Mr. Murphy had invoked in Gwinnett County. So move along to July 30th, which is approximately 30 some odd days later, and at 3 o'clock in the morning, Mr. Murphy was arrested on these charges. which had already been, I also want to note, Judge, that when Detective Ramos went to Gwinnett County, he made it very clear that he was speaking to Mr. Murphy about the homicide in Tampa. It wasn't as a result of the misdemeanor arrest that he had incurred when he was in Gwinnett County. So at 3 o'clock in the morning, and certainly in an interrogation not initiated by Mr. Murphy, Detective Drabick provided Mr. Murphy with acknowledgments or advisements as it relates to Miranda, and obviously at that time was fully aware that Mr. Murphy had previously invoked. And looking at Detective Drabick's deposition on 210, 211, I wanted certain times, I want to phrase exactly what Detective Drabick told Mr. Murphy. I asked in the deposition, is there any reason why you attempted to interview him after you already knew he had asked for counsel and invoked? And he said it was because it's a separate incident. And I asked the question, a separate incident or a separate interview? Because you were inquiring about the same thing that Tampa Police was inquiring to, right? And he said a separate interview for sure. The first incident, I do know he was under arrest for charges in Georgia. I wasn't present for that interview. So I can't really say for certain what he had actually invoked to. Well, Detective Ramos made it very clear in his testimony that he had indicated to Detective Drabick that he invoked as it related to questions being asked about the Tampa homicide. Essentially, moving forward, Judge, I note that Detective Drabick's posture at that stage of the game was essentially to tell him, and this is our quotes from the interview itself, that, listen, before I can speak to you about obviously whatever conversations we have, I just have to read you this first. If you have any questions at all about it, just let me know and I'll be happy to explain it. But directly after making that statement and the defendant saying, yes, sir, he doesn't, Detective Drabick that is, indicate or ask Mr. Murphy whether he is willing to waive those rights and speak to him. He goes directly into, okay, print your name here, print your first and last name, sign your name on the line, and then once you do that, I'm going to write my information. At that stage of the game, Mr. Murphy says, I'm shaking, I'm cold as hell, and Drabick says, well, you know, it's 3 o'clock in the morning, you know, I get it. Detective Drabick then, during the course of the interview, as set forth with particularity on page 6 of my motion, says he raises the Tampa detective's absence from this interrogation and states, and the defendant clearly states, look, I don't want to talk to them. I don't want to speak with those Tampa detectives. And there's a dialogue between he and Detective Drabick about why, and Mr. Murphy is clear about that. And that is found at page 13 and through 15 of Detective Drabick's deposition. Detective Drabick then distances himself even further from the investigation and emphasizes that, listen, Jacksonville's got a limited role here, stating that, we just were asked to step in. We didn't do any investigation in this case. I used to, work homicides, but I don't do that anymore. And I probably wouldn't even be able to call you out on anything because I don't really know anything about this case. And that also is set forth on page 17 of Mr. Murphy's interview. Mr. Murphy goes on then to deny any involvement in being in Tampa, and Detective Drabick starts to take another tact by suggesting he's the mastermind of this and describing what other people are saying about him, and going on to say this is going to be the most important conversation of your life, and that others in these kinds of rooms with their life on the line, who knows what they're going to say. And again, that portion of the interview is set forth on pages 63 and 64 as set forth word for word in the motion. Then Drabick goes on to talk about the strength of the Tampa investigation, in detail, talking about it being a fucking full meal deal, and that this is Tampa's investigation, not Jacksonville's. I'm not bluffing you because you've never seen an investigation and an interview being done in Tampa. I mean, you've never seen one of those. You've never been a party to one of those interviews. That Tampa has this thing and has done things that I don't even know existed with investigations. They're big wigs, and that, it's like in the fucking movie. So he goes on to, again, distance himself from the Tampa detectives, distance himself from the interview. Mr. Murphy at that time thereafter admits that he was in Tampa, but arrived after the shooting and essentially states that he has no involvement in the shooting itself. Judge, suppression is required under the totality of the circumstances based on four independent but interrelated reasons. Number one, law enforcement's minimization of the significance of Miranda, diluting what Miranda provides to a defendant when it's being administered. Number two, when officers fail to secure an express and affirmative waiver. Number three, when law enforcement employs a coordinated, like a multi-agency type of strategy that leverages the defendant and plays upon his mistrust of the agency doing the investigation. And finally, independently dispositive, but certainly I'm discussing these issues in an interrelated fashion, is that when the defendant previously unequivocally invoked his right to remain silent, before substantive questioning happened on July 30th, that needs to be honored. And in this particular case, in addition to it not being honored, it actually was leveraged in order to get Mr. Murphy to talk. Judge Edwards versus Arizona, United States Supreme Court case, talks about the two-part test to determine the admissibility of post-invocation statements. And those two-part test is, first, that the defendant must reinitiate with the police, which did not occur in this particular circumstance. And second, there must be a valid waiver of Miranda rights already invoked. And certainly that waiver can only be found if the individual is the one responsible for reinitiating, which is not the case in this circumstances. There's no question that Mr. Murphy previously invoked. There's no question that Detective Dravick was aware of that, and that Detective Ramos had indicated that that happened. Understanding, Judge, and I can't say I'm oblivious to the fact that the Supreme Court has also talked about whether and when there's a sufficient break in custody, that could permit a reapproach of the defendant if he has the opportunity to shake off the coercive effects of either a prior interrogation or the fact that there was an invocation. Here, there was about a 30-day period in the interim. Regardless of whether or not case law permits that renewed contact, the state still bears a really heavy burden to prove by the preponderance that the defendant's waiver was made voluntarily, it was made knowingly, and it was made intelligently. And I cite Hall at 248 Southern 3rd, 1227, which is a First District case, 2018. In this particular case, what occurs is that the interrogation shouldn't be considered as separate interrogations. They don't exist in a vacuum, especially in these circumstances. When we talk about what voluntariness there was in the waiver on the July 30th incident with Detective Drabeck, it's my belief, and I think that the evidence would support, that Detective Drabeck employed a coordinated multi-agency effort to distance himself and create a misconception in Mr. Murphy's mind that speaking with these Jacksonville officers was distinct and was distant from any cooperation or anything related to the Hillsborough County homicide, undermining his ability to make a free and deliberate choice. In this instant, Judge, there's a number of areas that I think need independent scrutiny. Number one, Miranda was minimized and phrased as a formality. As you look at the manner in which the transcript of the interview would suggest, Drabick didn't introduce Miranda as a constitutional decision type point. He minimized the entire process and essentially said, look, whatever conversations we may have, I just got to read this to you first. And once he did read the advisements, and I'm not suggesting he didn't read Miranda. He did read Miranda. But essentially, he says, look, I'm going to make this short and sweet. As soon as the Miranda advisements were made, he quickly says, hey, look, you understand that? Yeah, here, sign this paper, put your first name, put your last name. Never asked whether or not Mr. Murphy wanted to exercise those rights, whether he was in a position to fully understand those rights, and then instructed him pretty much to sign his name and let's move on. He did as he was instructed, and at that particular time, Drabick also noted that Mr. Murphy appeared to be fatigued, even offered him a Red Bull. He was covered in a blanket from head to toe, including his face and his head, and you can see that in the video portion of the interview, which has been admitted into evidence, and asked him whether he was doing okay, and at that particular time, continued the interview process. And I believe that under Ross versus State at 45 Southern 3rd, Florida Supreme Court case in 2010, the court concluded that detectives improperly minimized and downplayed the significance of Miranda in almost an identical circumstance. In Ross, the defendant introduced the advisement by saying, there's a couple things I need to go over with you real quick. There's a couple things I discovered, and before we go any further, I want to cover this with you. It's just a matter of procedure based on everything we're talking about. The court held that that language conveyed the impression that the warnings were clearly bureaucratic and a formality. And significantly, even though the detective in Ross requested an affirmative waiver of that right from the defendant, the court in Ross said that's still insufficient. We didn't even get that in this particular circumstance, which Ross got, and the court still ruled that, in fact, Miranda was undermined.
Well, the Ross case was pretty egregious, right? As far
Yes,
as the
Judge.
conduct of law enforcement. I mean, in that case specifically, the detective admitted that they violated their own policy at the direction of the sheriff.
And I agree, Judge, but I don't think it makes it more egregious, because I think regardless of the underlying reason why law enforcement did it, the pronouncements and the interaction between the defendant and law enforcement were the same, or in fact worse here than in Ross. I think clearly Ross confirms it, where law enforcement conveys that Miranda's a routine procedural step rather than a substantial safeguard, that any ensuing waiver is constitutionally infirm and should in fact result in suppression. I did cite for the court, because I do acknowledge it, the Thomas case, which is at 351 Southern 3rd, 197, where in that case the court rejected a Miranda minimization claim, but the court there emphasized that the detective repeatedly referred to Miranda as a constitutional right, and he expressly informed Thomas that he was signing a form, meaning that means you're choosing to speak with law enforcement and ensure that he understood the gravity of those rights, and he was waiving them in exchange for conversation with the detective. The court also relied on the absence of any deception, any distancing between two agencies, any suggestion that Jacksonville's different from Tampa and we're not the same and it's not really our investigation, we don't have much to do with this. And in this particular case, those circumstances that are set forth in Thomas are different. Drabick didn't describe Miranda as a safeguard. He didn't explain that signing the form constituted a choice to speak. And instead, what he did was he treated it simply as just a bing, bang, boom, let's get by this and move on. Secondly, Judge, and next, it's my belief that law enforcement, again, as I testified, or excuse me, argued earlier, he used this multi-agency interrogation strategy that exploited the trust that, or lack thereof, that Mr. Murphy had with Tampa, and attempted to utilize it in an attempt to gain trust without constitutional safeguards as it relates to Jacksonville. Before the substantive questioning and after getting the signature on the waiver, he starts, that's Drabick, deliberately distancing himself from the homicide detectives and telling Mr. Murphy that they're the decision makers here. You know, they're the ones, and it's their process and their case, and essentially pressing the defendant to cooperate after he had initially denied being in Tampa. So I would suggest to the court that because the defendant had unequivocally expressed that he didn't want to talk to the Tampa agents as it relates to this homicide, that's critical in the court's assessment as to the voluntariness of his statements.
But doesn't it cut both ways for your client? If he is understanding enough of his Miranda rights to waive them the first go-around, then doesn't that mean in the second go-around that I can conclude that he understood what Miranda meant and what his rights were?
Under different circumstances. When Detective Ramos read advisements, he just didn't say, here you go, sign this. He told him, this is your constitutional right. Are you going to waive it? Are you going to waive it in order to continue to speak to me? Verbatim. Right? It wasn't simply bing, bang, boom, here you go, sign it, let's go, whatever we're going to talk about, we're going to just start now. That is the distinct difference between the way Detective Ramos handled the advisements and the way Detective Drabick, with purpose, in my estimation, handled his portion of the interview. So no, I don't believe it cuts both ways, because I think it was done drastically differently. And not only, there was no underlying method of distancing that Detective Ramos used. He certainly wasn't talking about Jacksonville. He certainly wasn't talking about Gwinnett. It was very clear to him what was going on, and it was done, in my estimation, the right way. Without getting further into this
Just so you know, you're at 21 minutes.
That's fine,
So if you
Judge.
want any rebuttal time, then I'm just gonna advise you.
That's fine, Judge. Your Honor, at the onset of the July 30th interrogation, when he told Drabick that he didn't want to talk to the detectives in Tampa, rather than honoring and clarifying the legal significance of continuing to speak, essentially what Drabick did was he exploited kind of this perceived division between Tampa and Jacksonville and distorted the defendant's understanding of the risks and the consequences of continuing to speak. And I believe if the court reviews the interview on pages 13 and 14, you'll see this dialogue clearly play out, and it is set forth with particularity in the motion. And I'll say again, Judge, because I think it's important. Drabick warned during the course of the interview, this is Tampa's investigation, not Jacksonville. I'm not bluffing you because you never seen a Tampa interview, and there's a reason for that. He then emphasized the superior resources that Tampa has, that they are big wigs, they're like in the movies, and essentially to suggest that the cooperation through Jacksonville offered some safer or more advantageous alternative to Mr. Murphy at that time. And I believe that those coercive tactics parallel those types of circumstances that are condemned in the second district case of Bussey, which is at 184 Southern 3rd, 1138, 2015 Second DCA case. In Bussey's, the officers repeatedly minimized the seriousness of the defendant's conduct, contrasting the outcomes to suggest that cooperation would avert harsher consequences and foster the belief that you could be saved from the worst case scenario, and that is being interviewed by Tampa, or going with the bigwigs, or the movie guys, or the guys that you don't even understand how investigations go over there. Law enforcement distorted the defendant's understanding of the risk in order to overcome any resistance and secure a statement, which in this particular case is more important than Bussey because there had been a previous invocation, and Detective Dravik was aware of that. And again, suggesting that talking to Jacksonville was safer and more advantageous than dealing with the big Tampa machine, for lack of a better word. Judge, there's no dispute that Detective Dravik failed to honor the invocation because the substantive questioning commenced without interruption. We went straight full blast, 100 miles an hour, from an advisement without the proper after statements by Detective Dravik that would ensure that Mr. Murphy fully understood and voluntarily and with knowledge waived his Miranda rights. Detective Dravik exploited it. He leveraged that refusal, and essentially he fostered trust in a subversive manner. I'm sure the state's going to suggest, and certainly the court has heard in the past, well, the government or police officers, detective, can use lies. They can use methods in order to seek a statement. But in this particular case, it rises to the level of egregiousness based on the prior invocation, based on the differences and the way that Mr. Murphy perceived the advisements and the statements given to him by Detective Ramos versus the type of atmosphere that Detective Dravik fostered, knowing that there was a prior invocation. Under the totality of the circumstances, Judge, I don't believe the state can meet its burden to prove a voluntary, knowing, and intelligent waiver as it relates to the July 30th statement. Again, and in finality, Miranda was minimized, and it was framed as merely procedural. Number two, Detective Dravik failed to secure an affirmative waiver of those rights, which I believe incumbent on him to do, as Detective Ramos did during his interaction with Mr. Murphy. Third, that he exploited this artificial Jacksonville-Tampa divide in order to specifically distort Mr. Murphy's understanding of the consequences of speaking to him. And finally, he ignored and then leveraged a prior invocation to remain silent. And because those resulting statements were not freely and voluntarily given, we would suggest to the court that the July 30th statements must be suppressed.
Okay, thank you very much, Mr. Gonzalez. And State, did you provide me any case law ahead of time?
I did, Judge.
No, you did. I'm talking to the state.
Judge, we did not. We're relying on the same case law that Mr. Gonzalez relied on. We do not dispute that on June 26th of 2024, that first interview that occurred in Georgia, that Detective Ramos was there specifically to question him about the homicide, but it's also undisputable that he was not arrested for the homicide in Tampa, that he did invoke for his right to request an attorney, and that was honored. That interview was immediately terminated. You heard the audio recording.
I'm
of what
sorry, I'm gonna
happened.
interrupt you for 1 second. Mr. Sonardi, you have a very deep voice, and I can hear you talking to Mr. Hernandez, so I don't know if it's,
Apologize, Judge.
it's okay. I don't know if you're capable of whispering, but if you are, please.
I'm trying.
Okay, all right, very good. All right, continue.
Yes, Your Honor. It is also undisputable that that right was honored by Detective Ramos, that he terminated that interview. And what is also undisputed and what is fact is that he was arrested on Georgia-related charges and he was let go. So he was released, and that occurred in June 26th of 2024, and there was a break of over a month. And so I know that Mr. Gonzalez mentioned U.S. v. Edwards. That is a exception when a person has invoked his right to an attorney that is carved out by the U.S. Supreme Court. The other exception that is also carved out, which is applicable in this case, is Maryland v. Schatzer. And it is very clear in Maryland v. Schatzer, who a defendant who was in custody and was imprisoned was questioned, invoked his right to counsel, and the detectives in their investigation left the prison, and there was a break of 14 days. And after 14 days, those detectives reinitiated contact with the defendant. And the court, the U.S. Supreme Court and Maryland v. Schatzer found that that was a significant break, that 14-day, that 2-week period, that the defendant at that point could shake off the coercive nature of being imprisoned, could acclimate. That is a valid exception to when law enforcement can reinitiate contact. And that is what we have here, Judge. But we have a less coercive situation than Maryland v. Schatzer, where the defendant was serving a prison sentence. In this particular case, the defendant was arrested on Georgia charges. He then was released, and a month went by, over 4 weeks, not the 2-week period that was acceptable in Maryland v. Schatzer, but 4 weeks went by before law enforcement arrested him and developed probable cause to arrest him in this homicide related to Tampa. So that is what is significant, and that is what the law requires when somebody who has invoked their right to an attorney. So we have that break. And when we're talking about the totality of circumstances, and that proving the defendant knowingly and voluntarily waived his rights to Miranda, certainly the first reading of Miranda that happened within a 2-month period, which was recorded on audio recording, that where his rights were fully read to him, we all heard it, and he acknowledged and he understood those rights, and so much so that he understood them, that he actually exercised those rights by invoking an attorney. We have no reason to believe within a 2-month period that all of a sudden he no longer understands his constitutional Miranda rights. He definitely exercised them on June 26th of 2004. And so when we're looking at the Miranda on July 30th of 2024 with Detective Draybeck, and looking at those totality of circumstances, all of the factors for the court to consider, Detective Draybeck, again, we have not just an audio version, we have an audio and recorded version. So they recorded their interaction with the defendant. There is a written form that was used, and clearly the detective, again, read all of the Miranda rights to the defendant. He made the defendant read the first sentence of the form to make sure the defendant could understand what he was reading. And then the defendant, again, acknowledged and signed off on his Miranda rights and continued to talk to the detective. There was no deception to the defendant trying to say that this wasn't related to the Tampa case. That was made clear to him that they were there to interview him for those specific purpose was to talk to him about the Tampa homicide. He never invoked his right to remain silent. He never asked for an attorney. He made one statement about not wanting to talk to Tampa detectives, and he clarified to the detectives why that was. It wasn't because he didn't want to talk about the Tampa case. He said because they don't know me. So there is nothing improper about Detective Draybeck trying to build a rapport and using strategic tactics to get the defendant to talk to him. So certainly if he wanted to play up that whatever and distinguish himself from Tampa, he still made it clear and was honest about what he was there to talk to the defendant about. And the defendant at that point never exercised his rights and never invoked his right to remain silent. That was a willing, knowingly, and voluntary waiver of Miranda that is recorded for all of us to hear. And it is definitely distinguishable against Ross, where they were looking at bad faith and bad actions by law enforcement. You do not have that here. That is a far distinction. You can't just qualify Detective Drabeck's interaction with the defendant and try to put it in a bad way. There was no promises that were made. There was nothing coercive about that interview that is on video. You could see there the manner in which it was taken. It was professional, and he was cold. They were the ones that provided him with the blanket. So when you're looking at the totality of circumstances and what the law requires, there is nothing that needs to be suppressed in this particular case. There was enough of a break that occurred. He was no longer under the coercive nature of being in custody. He had been released from the Georgia authorities, and he had never been arrested for this Tampa homicide. 30 days had passed. That was sufficient of a break. And according to Maryland v. Schatzer, that was sufficient for law enforcement to be able to reinitiate contact with the defendant and reread him his Miranda rights. And so we would ask that you deny the defendant's motion to suppress the statements and the recorded interview that he provided to Detective Drabeck on July 30th of 2024.
Okay.
Judge, I would only add that, as the court knows, the video interview is in evidence, and I would urge the court to review it in order to make determinations that would be consistent with my argument.
Okay, very good. I'm going
And
to
I
take
have
it.
no objection to that, Judge.
I'll take it under advisement. Okay, I'm going to do a written order on this one. Okay. All right, so Mr. Gonzalez, you want to move on to your motion, Defendant Rashad Murphy's motion to suppress cell phone?
Judge, I am moving to suppress all evidence seized from the defendant's cell phone incident to an unlawful search warrant. Very quickly, court's aware, Gwinnett County, the LPR readers locate the silver Chevy Cruze, which is the subject, the vehicle is the subject of an alert put out by Detective Ramos based on surveillance video that was developed from various areas and specifically the scene of this particular crime. When Mr. Murphy is taken into custody, again, the court's aware that the cell phone was located in the vehicle, and it was open to show GPS directions back to the hotel. It was determined what the phone number was of that cell phone, and also that it was registered to Charmaine Steiger, who is Mr. Murphy's girlfriend, but that it was clear and unequivocal that both individuals utilized that phone. Detective Ramos authored an affidavit for a search warrant for that phone because he was aware of the evidence that had come to light at that particular time in the investigation, which was early on, within days. And certainly I have listed, or I have made that cell phone affidavit, Exhibit A, in the motion, and I would urge the court to read its probable cause. What happened in conjunction with that is that Detective Carter, who took upon herself the lead investigator in Gwinnett County based on the arrest, the subsequent statement of Ms. Steiger, and also all things forensics that occur in Gwinnett County, she included at the back end of that affidavit her additional statements or evidence as it relates to probable cause for that search warrant. And she and Detective Ramos are co-affiants to that search warrant. Judge, I have set forth in page 3 of my motion a synopsis of all of the evidence that provided alleged probable cause for this warrant. I would note to the court in subsection J, essentially the only thing that has any relationship, direct or indirect, well, certainly not direct, but indirect, is that Tampa police had initially contacted Jacksonville because of the vehicle being a Duval County plate. And at that particular time, I'm not even sure Detective Ramos, pursuant to his testimony, even had an owner, registered owner, certainly had not contacted a registered owner, had no idea that Mr. Murphy had anything to do with that vehicle other than he was the driver of it in Gwinnett County when it was stopped. And essentially, that general information was that there was intelligence, and this, again, Judge, runs kind of dovetail into a lot of what we're talking about over the past week and now, where the Jacksonville detectives tell Ramos, hey, listen, we got intelligence which says that 2 out of the 3 shooters might be Isaiah Chance and Rashad Murphy. There are no witnesses to confirm this. There is no direct evidence of it. There is no forensics to support it. There are no videos to support it. There is no fingerprints to support it. There is no eyewitness or other direct witness testimony to support it whatsoever. It is a rogue statement by Jacksonville based on hearsay. And I think that's unequivocal. And I don't think anybody, inclusive of when Detective Ramos testified and then discussing it with Detective Drabeck, ever suggested it was anything more than rank hearsay. So at this point in time, the only thing that is determined by that statement as probable cause in this affidavit is that Mr. Murphy might be a person of interest. So moving on, what ends up happening is Detective Carter, in her deposition on page 14, states that she had no idea who Rashad Murphy was. She wasn't provided any information with regard to Rashad Murphy. She wasn't told that Mr. Murphy had any connection or had any potential part in this particular murder. She thought, and she was told, it was the vehicle. It's the vehicle at issue here. So that is the premise under which Gwinnett County detectives are operating under, and it's the premise under which she's operating when she executes that probable cause affidavit for the cell phone search warrant. Detective Ramos, in turn, both in testimony last week and in his January 15th deposition on page 14, said, my original probable cause was for the car. So if the phone's in the car, then the phone becomes an extension of the car. Well, we all know that is not what the law is. That phone is not an extension of the car, and the only thing that Detective Ramos is operating under at that particular time is that there's an alert for this car and it's now in custody. And he goes on to testify in page 14 and 15 of his deposition that where Rashad Murphy was, that's where the phone was. It's a totality. So all of that information gets included. So again, that is what in his mind premised the probable cause for this affidavit. He goes on to testify on January 15th, and again last week, that he had not identified Rashad Murphy, that all he knew was based on Jacksonville intelligence, nothing more than that, the intelligence coming from Jacksonville. And then my question was, which was, we believe that for one reason or another, Rashad Murphy was involved? Answer, correct. And that's really as general as it got. There were no other additional information with any specificity about how, why, and what. His response, correct. So although Ramos identified the owner of the cruise, he admitted that he had done no further investigation on that cruise, Chevy Cruise whatsoever, and certainly could not connect it to Rashad Murphy as it relates to a crime, as it relates to a murder. Simply that days after the murder, he was in contact with it or he was the driver of it. Without having any context as to why that would even be the case, later to learn, obviously, it was a relative's vehicle, but certainly not being privy to that information at the time of the search warrant, at the time of the affidavit. So, Judge, in discussing those underlying facts, cellular phones are recognized as having very, very unique characteristics because of both the breadth and the depth of personal information that they have in them. And certainly that's buttressed by a number of federal court cases and Supreme Court cases, essentially saying that a cell phone collects in one place very distinct types of information that reveal much more in combination than any other isolated record. So to that extent, there is significant scrutiny when it comes to cell phones and what they contain. When determining the legality of a warrant, of course, the court's well aware that you look at the four corners of that affidavit. And I will not get into the four corners of the affidavit. They are set forth in the case law and in the motion with specificity. But I will say that certainly mere speculation as to whether or not there may be some evidence of criminal activity that might be found is wholly insufficient to support the issuance of a warrant. Additionally, Judge, even if that warrant on its face appears to have probable cause, I would suggest to the court that the case law is clear that the omission of material facts obviously render that warrant unlawful. And we'll talk about that. In this particular case, Judge, and with particularity as it relates to this particular case, the warrant lacked probable cause because the affidavit failed to establish that Mr. Murphy committed a crime, and it failed to establish a nexus between that cell phone and the evidence of any criminality. There is no nexus sufficient to authorize a search warrant in this case with regard to that cell phone based on the totality of circumstances. In particular with the cell phone, in order to search a digital device, it requires more than the possibility that that phone might have evidence of a crime. And when you talk about those things, as I set forth in the motion, you talk about the dichotomy between two particular cases that I would reference, Jefferson versus State, which is a second district case, a 6th district case, and also Torres-Carmona, which is a second district case. In Torres-Carmona, the second district upheld a warrant that was supported by a detailed multi-agency investigation establishing an evidentiary chain linking the defendant, linking his co-defendant, linking the victim, and linking the use of the cellular devices prior to and during the commission of the crime. None of that exists in this particular case. No mobile phones were located on Mr. Murphy's person. His phone does not travel to Tampa. Those are just a few of the things that certainly would not give rise to the same factual scenario in Torres-Carmona. In that particular case, the victim's girlfriend told investigators that she provided those phone numbers. Detectives received cell tower information and call detail information on that phone. And critically, in Torres-Carmona, the investigation demonstrated a coordinated pattern of travel for that phone. In short, essentially, the phone and the evidence of that phone was not speculative. When you contrast that with Jefferson, the court held there that officers lacked probable cause to search a defendant's phone where they assumed that the defendant's phone would contain incriminating communications, but they didn't importantly establish a factual links between the device and the crime, which is a critical distinction in this particular case. The defendant in Jefferson, it was a first-degree murder case of the death of a female acquaintance, and although they could place the defendant near the victim, which can't be done here, they can connect him to the crime scene through physical evidence, which is not the case here. The affidavit relied on conjecture that communications likely existed on the defendant's phone. And the court noted that the facts which were known to the officers when they seized it is that there was a blood trail from the victim's body to the defendant's apartment. And this is where the court found a lack of probable cause.
It's about the Jefferson case?
Jefferson case, Judge, at 363 Southern 2nd.
But there was not a warrant, excuse me, yeah, there was not a warrant in that case, right?
No, Judge. The defendant was previously acquainted with the victim, and that 2 days before her body was located, they were seen together, and that the defendant had been less than forthcoming in prior interviews. So all of those things considered, the court still found that regardless of that circumstantial evidence, law enforcement did not establish probable cause to search the defendant's phone. It's not buttressed with anything of specificity that Mr. Murphy might be a person of interest. That is it. That is what is utilized in the entirety. If you look at the entirety of this 4 or 5 page probable cause affidavit, none of it would be something that a magistrate should be would find compelling to provide probable cause for this warrant. And the only time that Mr. Murphy is mentioned in that affidavit is when we talk about the fact that Jacksonville said, "Hey, look, he might be one of our guys." Mere association with that vehicle that was subject to involvement, without evidence linking the defendant to that vehicle during the course and scope of the crime, cannot support the issuance of this warrant, Judge. Third, the affidavit fails to establish a nexus between the cell phones and any evidence of criminality, and we've discussed that, but I go into it in more sufficient detail in the motion on page 10 and 11. And I would point out to the court again that Detective Ramos is under the impression that simply because the phone was found in the vehicle, that makes the phone an extension of the vehicle. And the vehicle was the subject of the evidentiary inquiry, not the phone. None of which had any direct relationship to Mr. Murphy and the crime. Not Mr. Murphy at the time the phone was found, Mr. Murphy and the crime, which is required under the law in order to seek and get this warrant. Judge, as it relates to omissions, I think the fact that the affidavit contained omissions would, had they been included, defeated probable cause is also an issue in this case. Detective Ramos admitted and testified that there was no evidence linking the defendant to the homicide. The affidavit, in a sense, misrepresented the intelligence that was received from Jacksonville. And if you look at the way that it's postured in the affidavit, compared to under oath, what Detective Ramos says, Detective Ramos had in-depth knowledge of the victim, the gang he affiliated with, and the gang rivalry he is feuding with, and Detective Drabick identified the defendant as a suspect. That is the premise by which Detective Drabick suggests that there should be some nexus or some linkage to this phone. And specifically, in Detective Ramos's deposition, I again asked, had you at this time identified Murphy? I knew the name based on the intelligence, but I had nothing more than that. You know, intel from Jacksonville. Question, which was, we believe for one reason or another that Rashad Murphy was involved? Correct. and that really is as general as it got. Correct. I highlighted that before, and I'm going to highlight it again, because that is what Detective Ramos is operating under in truth, but that is not, in fact, the way that the affidavit is suggested when it's written. Despite admissions in sworn testimony by both Detective Carter in her deposition as set forth in the motion and Detective Ramos both in testimony before the court and in his deposition, that they had no evidentiary basis to connect Mr. Murphy with the homicide, or even to place him in Tampa at that time, that fact is omitted from the affidavit. The affidavit also suggests that the homicide was motivated by ongoing gang activity, and it doesn't contain anything that would suggest at the time that the affidavit was written, the defendant was not a documented gang member when the warrant was issued. The defendant was never identified as a suspect in any ongoing gang investigations referenced in the affidavit. And the defendant and law enforcement had no evidence connecting defendant to any gang rivalry. What we had was that general statement given by Detective Draven, none of which was suggested to the magistrate in terms of specificity. Because if they had provided specificity, it would have indicated to the magistrate that there was no nexus that could be developed at that time, at the time in which the warrant was sought. Disclosure that they possessed no evidence linking Mr. Murphy to the homicide, and they believed that the probable cause was only extended to the cell phone from the vehicle itself, I believe would have defeated the application. Judge, at the end of the day, we always talk about good faith exceptions, and certainly when officers omit material facts or when they have no reasonable ground for believing that the warrant was properly issued, the good faith exception does not apply, and it doesn't apply here. At the end of the day, Judge, the affidavit does not link Rashad Murphy to the commission of any crime, does not establish a nexus between the cell phone and any evidence of criminality at all. And moreover, because there are omissions, as I've discussed, and have with more particularity citing deposition transcripts in the motion itself, those omissions could have altered a magistrate's finding of probable cause. And in that light, Judge, the evidence should be suppressed.
Okay, thank you. Story.
Yes, Your Honor. Judge, it's the state's position that law enforcement relied upon a properly executed search warrant, and what we want to make clear and make a proper distinction is there is a distinction between probable cause to arrest a defendant and probable cause to search a item of evidence that probable cause has been developed to search. I know that Mr. Gonzalez said that there was no evidence that defendant Murphy had committed the crime at that time. Judge, what is laid out in this search warrant is that a homicide had occurred in Tampa that involved 3 shooters, and all of the facts of the homicide have been laid out. So the crime that we are talking about is homicide, and there is PC that suggests that 3 shooters committed this homicide. There is nothing that requires or limits the state or law enforcement to only search items of evidence that belong to the suspects. We have to provide probable cause to search an item that may have evidence of the homicide. And so what is laid out in the search warrant, and we know that we are stuck by the 4 corners of this affidavit, and the reason that we provided testimony from Detective Ramos is to establish that there was no deception in the search warrant and there was no material omission. And we relied upon a properly exercised search warrant that was executed up in Duval County in Jacksonville. And there, when we talk about the probable cause for that phone, there was an executed search warrant for the car, and nobody searched that cell phone once it was located in the car. Nobody opened up that cell phone or searched it until there was a properly executed search warrant for that specific phone. And so when you're talking about the probable cause that is laid out by both the detectives who needed a co-affiant because this was done in a jurisdiction outside of Tampa, the detective is clearly laying out the probable cause to believe why there is evidence of the homicide in that phone. It includes all of the facts in Tampa that led to the crime and the murder of Charles Jones, but it also lays out and details the evidence of what occurs. This defendant is in the suspect vehicle within 3 days of this homicide occurring, and he immediately flees from law enforcement when he is apprehended in the very vehicle that they used to shoot and kill Charles Jones, the victim in this case. And when Mr. Gonzalez specifically refers to the statements that were provided by Jacksonville in the investigation where this defendant's name came up, they are using the exact accurate and honest depiction of what is going on. They label it as exactly what it is. It is just intel. And then they go beyond that and they tell the court, the magistrate, what that intel is. And then what is added about this particular phone is a part that Detective Carter with Gwinnett County Police Department in Georgia adds, that she actually had an interview with Charmaine Steiger, the defendant's girlfriend, and that involved the phone, and that Ms. Steiger let them look at the phone, withdrew consent, but she also gave a detailed interview after being confronted with the fact of this suspect vehicle and the whereabouts of her and the defendant during the time of the crime, and that she gave inconsistent statements. So all of that is woven into the probable cause. And so when we make a distinction about probable cause to arrest the defendant versus probable cause to search that particular phone because it has evidence related to a homicide case, that is clearly laid out in this search warrant. And based on Detective Ramos, there wasn't anything deceptive, there wasn't any omission that was given. He never tried to suggest that there was any evidence more than other than the defendant at that time was a person of interest, that they had an interview that of the girlfriend that claimed to be with the defendant the entire weekend and then changed her story once she was confronted, that the detectives absolutely knew that that car wasn't in Jacksonville when the homicide occurred, but was in Tampa. She then changed her story and said she didn't really know where he was. All of that is laid out in the search warrant. And so there is PC that a homicide had occurred in Tampa, that 3 shooters had participated in that shooting, and that there was evidence directly now related to a joint phone belonging to Charmaine Steiger and the victim in this case. And so there is no omission, there is no denial, and there's no sort of any additional facts to make it more suggestive than the defendant was involved that was actually in place at the time when the search warrant was executed. And so based on that, we would ask that you deny the defendant's motion to suppress. This was a good faith reliance upon a properly executed search warrant for that phone. That case law, that Jefferson case law is clearly, that was cited by defense, is clearly distinguishable. That's when they just went into the phone. That is not what happened here.
That was a warrantless search.
Correct, Judge. We have a warrant, we in good faith relied upon it, and there was nothing deceptive by either detective, and there was no material omission in that search warrant. Nobody suggested that there was PC to arrest the defendant at that time. Certainly, there were facts, even at this time, when this search warrant was executed, that he certainly was a person of interest, but they accurately noted in that search warrant that they just had intel, and that hearsay that the defense attorney is suggesting that that intel is based on, that is laid out in the search warrant. They're not saying that this was provided by a reliable CI, or they're not trying to suggest they had any additional evidence. It is spelled out exactly with the sort of intel that they had from Jacksonville. and there is sufficient facts in there to believe that there is evidence related to the homicide that occurred in Tampa based on the interviews that were done prior to the execution of this search warrant.
Briefly,
Yep.
Your Honor, the fact that the phone was not searched before a warrant was sought does not cure its illegality. Good for the police that they just didn't jump into the phone and start looking at it. That's not the issue. The issue is, did they have a sufficient nexus between the defendant and any act of criminality that would allow them to usurp the rights of privacy that he had in that phone when, and in fact, they knew that it was co-owned or belonged to him?
I understand the argument you're making regarding the nexus. I do.
Nothing further, Your Honor.
Okay, all right, very good. I'm gonna take the matter under advisement. I will do a written order. Okay, so we've got two motions by Mr. Gathright and one by Davion Murphy. Davion Murphy, you wanna go ahead, Ms. Toomey? On your motion to suppress? Okay, very good.
Judge, this is a motion to suppress the search and seizure of Davion Murphy. There was, so let me just back up. Mr. Murphy was actually, Davion Murphy was arrested on January 6th of 2025. There was originally an arrest warrant that was put out on Mr. Murphy, Davion Murphy, on July 27th of 2024. That was recalled when an indictment was issued, and the capias was issued on August 15th of 2024. So after Mr. Murphy, Davion Murphy was arrested by the Jackson County Sheriff's Office, he was initially read Miranda. He was brought into a room, he was handcuffed, he was still in street clothes, he had a red tank top on, a jacket, if I recall the weather during that time, I'm sure it was cold. The interview went on for a variety of hours. Mr. Davion Murphy cooperated with law enforcement, but then there was at the end, and I might note, and this is Defense Exhibit 1 during that motion, that during that time frame, Davion Murphy had his jacket zipped up, all the way past, up to his chest, almost up to his neck. Just for the record. I know I didn't play that portion, but it is on that interrogation video. Now, as I see it, without a warrant, there's about 3 exceptions that potentially the state could potentially argue. 1, the photographs were taken incident to arrest. 2, Mr. Davion Murphy consented to being photographed. And then 3, we've got the plain view doctrine. Whatever tattoos that were in plain view of law enforcement. So I just want to kind of briefly go through each one of those.
What
With
about
regard-
inevitable discovery?
Inevitable discovery, yes, which in my mind goes into the incident to arrest, because, and I guess I'll take that one first. Incident to arrest, you have the purpose of that exception to the search warrant is for not only officer safety, well, one of the primary reasons is for officer safety, but when someone's arrested and they're booked into county jail, what have you, again, officer safety, inmate safety, to make sure that individual's not bringing any contraband into the jail. There's a booking photo. They do not take photographs of any portions of your body other than to take a booking photo of you, to document the identification of who they've been arrested. They take fingerprints, they ask you a myriad of questions, background information. These are purely administrative procedures, and they're routine when someone is booked into county jail. So I don't think that inevitable discovery without a warrant, if the Jacksonville or TPD as indicated by Jacksonville Detective Drayback, who said, we're just trying to speed things along, so that when you get to Tampa, things will go smoothly for you. And I quote
So
that.
let me ask you this question, and I don't
Yes,
know
Judge.
if you know the answer, but the DOC records, would the DOC photographs have ultimately shown these tattoos on the body or person of Davion Murphy?
My experience is no. Now, I can tell the court that I have photographs, not photographs, excuse me. I have records from a variety of clients of their DOC records. The only thing, just as a booking photo and the questions that are asked during the booking process at the jail is, do you have any tattoos? They give maybe like a general description. If they have numerous tattoos, the booking officer will just put numerous tattoos, may go a little bit further, but
What about
Maybe get a gen-
photos, though? Are photos taken by DOC?
I have not seen photographs. I've
Okay.
seen where they've maybe described certain tattoos, but I haven't seen photographs. I have not.
Yeah, I
Perhaps
don't
it's-
know, that's why I'm just asking the question.
Yes, Judge. So just because Mr. Davion Murphy was in custody, obviously, he was brought in under that arrest warrant, he was shackled and brought in an interrogation room in Jacksonville. Just because he was in custody and just because he was arrested does not give law enforcement full blanche to photograph any and every area of his body that they think is gonna provide them what? Evidence, right? Because oddly enough, well, I'll get to that. So we have the incident to arrest. Also, part of the incident to arrest would be, well, potentially the individual is, the evidence might be lost in some fashion or another. We're talking about tattoos, so that's not applicable here. The second potential exception would be consent. And when determining consent, the court has to consider the totality of the circumstances. And I would submit to the court that Mr. Murphy, because he was in custody, he had just been interrogated by Jacksonville Sheriff's Office, that he, not only was he wasn't, in my opinion, was not asked. The officer told him that he wanted, but what and I'm gonna quote, what I wanted to do is I'm going to take some pictures of your tattoos. That's what he told Davion Murphy. It's not a question, it's not asking him for consent, it's telling him what he is going to do. And mere acquiescence of authority is not enough. And the state has the burden to prove that there wasn't a mere acquiescence to the show of authority. In order to show that Davion Murphy consented, the state has the burden to show that his consent was free and unrestrained. It was an unrestrained choice that he had made. I haven't been provided anything wherein it was explained to Mr. Murphy that he's consenting, that he's signing, that he's got a right to not consent, right? That was never explained to Davion Murphy. So I think in the totality of the circumstances, there is no consent by Davion Murphy to the photographs, which, by the way, were personal in nature in that he lifted up his shirt. These are not portions of one's body that are in plain view. And again, these are not photographs that are taken when someone is arrested. Yes, someone who is detained, a detainee in a jail, has less privacy rights than the average individual, and they do. But does that mean that the state and law enforcement get to trample on his constitutional rights as well, when they could have simply got a search warrant? I have other cases where they want to see my guy's tattoos. They obtained a search warrant and went and took photographs of the individual's tattoo that they thought had a nexus or were related to the crime involved. So, looking at the totality of the circumstances, I don't believe that Mr. Davion Murphy gave consent. Now, plain view, obviously the stomach is not in plain view. One of those photographs, the detective admitted, and you can see in the photograph where he actually pulled back. The back of his neck, the tank top pulled it down. So obviously, those areas are not in plain view.
So you're saying the back of his neck is not in plain view?
No, that tattoo, specifically that tattoo, where he had a tank top on, right, after he took his jacket on.
It says, I think, 1,200, right, on the back?
Yes, Your Honor.
Okay.
That was not in plain view because the officer, or the detective, actually had to pull his shirt down from his back in order to observe that and take photographs of it. And because there was no search warrant obtained by the state, the burden is on the state to prove that one of these exceptions apply. These motions, defense 2A through L, should be excluded, as well as the portion of the videotape where those pictures are being taken. And inevitable discovery, that's, yes, potentially. If the state had gone in the correct manner and getting a search warrant to begin with. Because, that's the whole idea of the exclusionary rule, right, is not to reward misconduct or bad behavior by detectives and the police department, right? So it would have been, they got all these other search warrants, it would have been that quick to get potentially, if they had probable cause, to get a search warrant for these tattoos that are on Davion Murphy's body, which they so desperately wanted to utilize in this case as evidence that he is part of this 1200 or the 187 gang or no hospital gang or what have you. I might also note that the state, in providing the different groups, associates, members of ATK, members of 1200, one of the photographs that was used was from the interrogation room. And we'll get, I guess that's probably a subject of another motion, so I'll leave it at that. But I would request that those photographs be suppressed.
Okay,
Thank you, Judge.
thank you. Ms. Murphy?
Good morning, Your Honor.
Morning.
I will address the specific exceptions. The state's position that a search warrant was not required in this case. If we are looking specifically first to the search incident to arrest, the defendant was lawfully arrested on a warrant. Law enforcement has the wide breadth in conducting a search of the defendant. By law, Florida statutes 901.21 conflict with the defense's argument that this was some kind of intimate or private search. The only description that's provided in that statute as going so far as to be a strip or cavity search, something that's outside of the scope of the search of a person arrested lawfully, would mean the chest or breast of a female arrestee. So the defendant does not qualify. This is not some personal search or strip search or cavity search, nonetheless. That being said, the jail and law enforcement also have the ability to do so when the defendant has been lawfully arrested. So a strip search or cavity search, again, is conducted by the jail or law enforcement as long as it's done so in a manner and location that is reasonable. The defense would argue that the defendant had a right to privacy in the areas that were depicted, but as the defendant entered the interrogation room, his jacket was already off of his shoulders. The 1200 on the back of his neck was exposed. The block, so 1200 block is what the full tattoo is on the back, was not exposed, and that is what was covered. So the word block on the neck and the tattoo on the chest or stomach area are what really appeared to be at issue. Other tattoos include those on the defendant's hands, which were obviously in plain view, and the side of the defendant's neck, as well as the upper chest area, also all in plain view, applying or meeting the standard for a plain view exception. Additionally, as it relates to the defendant's consent, when it comes to those areas, I think the question asked of the defendant was, what's that belly looking like? At the time that the defendant lifted his shirt, obviously not necessarily needing to establish consent to prove that the law enforcement officers did not need a search warrant in order to obtain these photographs. The state would argue that that was consent to at least obtain the photographs on the stomach, but most importantly is inevitable discovery. The jail does in fact document the description of the tattoos, their location on each of these defendants' persons, but also these law enforcement officers are acting in a manner that is an extension of the jail. They are permitted to take photographs even if they were roadside of an arrestee when they see, for example, on someone who's been arrested for murder with a gang enhancement, tattoos indicative of being a gang member. That said, the Department of Corrections does in fact photograph gang members. So the records that Ms. Toomey may have been referencing for Department of Corrections records received for her by other cases or with other defendants referenced may be what's called a penitentiary pack, or referred to as a penitentiary pack. That commonly includes a photograph of the defendant or the most recent photograph of the defendant that's been taken by the Florida Department of Corrections, their classifications and locations over the term of their time in the corrections department or prisons that they've been sent to, transfers, incidents, and fingerprints. That is the standard penitentiary pack. This particular defendant, though, has a designation, which means that he is on notice and noticing law enforcement agencies that he is in fact a gang member. That is a different document from the Department of Corrections. But each time the defendant would be transported, each time that the prison that he is located in would see additional tattoos or gang evidence, including his interactions or incident reports for having contact with the guards for gang activity, it's all documented. But thoroughly documented, as confirmed by the defendant in his interview, are his tattoos. So he specifically says to the detective, you already have those, the prison takes those, etc. Because in fact, what's called a STAR report from the Department of Corrections is specifically the Department of Corrections log of each inmate and every tattoo on that inmate's person. It's not only to keep track of the gang activity, involvement, developments, etc., but also to ensure that they are cracking down on the illegal tattooing in custody. There are several reasons for it, but they certainly monitor each defendant, not only at the time that they notice new tattoos, injuries, that type of thing, but also at the time each of the defendants are transported. It would, I can only assume, appear from the defendant's interview that he acknowledges and admits to that, because he repeatedly says to the detective, oh, the prison already took them, those are the most updated ones, and I received them all in prison.
I'm just curious, does every inmate get a STAR report in DOC, or just those that are suspected of gang affiliation?
Only those that are documented as having some involvement with a gang. So everyone gets a penitentiary pack, that's the basic information, and then if there's a gang attachment, that's a STAR report, that's the gang report essentially. So at this time, Your Honor, the state's going to request that the court deny the defendant's motion as it relates to the defendant's tattoos having been taken by Detective Nieder. The Fourth Amendment certainly protects, just at a basic level, the search that was conducted. There was the scope of the intrusion that should be considered, the manner in which the search was conducted, the justification for initiating that, which of course is the charges in this case and the facts surrounding it, paired with Detective Nieder's knowledge of these gangs, and the place that it occurred, which of course is in the privacy of a law enforcement district room, not on the roadside or something along those lines. So starting first with a Fourth Amendment analysis, law enforcement didn't violate any of the defendant's rights, but also in the event that the court believes that a search warrant would have been appropriate, the exceptions that the state would be relying upon are a search incident to arrest, plain view, consent, and obviously, most notably, the inevitable discovery of those records, which would have already been documented.
Okay, very good.
Thank you.
Okay, let's just go ahead and take our morning recess. It's 10:33. I'll be back at 10:45, and then we will proceed with Mr. Gathwright's motions.
Or to recess.
Under advisement.